Hi, y'all, and welcome to tonight's live stream. Today was an absolute nightmare for Karen Reed's defense team. The hearing was very tough. It is looking increasingly like the judge may actually toss Alan Jackson, the superstar who headed her case in the first trial, might actually toss him from the case. And it's even possible that she may toss the local attorney, Yannetti, maybe even the other two attorneys as well, although I don't think so. The judge on her own brought up a new situation where she believes she was lied to by Alan Jackson and asked about it. Now, the judge has not made a decision. She hasn't even finished the hearing yet. She had to cut it off at 4, so the hearing's going to be continued. But what happened today is absolutely critical and pivotal for how Karen Reed proceeds to trial and for just how it goes coming up. So tonight we're going to talk about it. We're going to talk about what happened. The defense was headed by today, the only speaker for the defense really was Robert Alessi from New York. He is a phenomenal lawyer, just absolutely phenomenal lawyer. He is as good at argument, I think, as Alan Jackson is at cross-examination of witnesses. And they let him handle it, which was very wise because he wasn't involved in any of the issues that the judge is concerned about. And so he could handle it more easily than any of the other lawyers could have. But the judge came out swinging from the get-go, talking about whether the defense had hidden what she called, quote, a previously undisclosed relationship, perhaps, with expert witnesses who testified at the first trial. Alessi was just as hard-hitting in an extremely long argument. But by the end of the day, I think it was pretty clear that the judge really was not buying the arguments that the defense was making. So in a nutshell, what this is about, the defense used 2 witnesses who had been hired by the federal government in an investigation the federal government was doing into some local, well, we think it was into troopers, some of whom happened to actually investigate Karen Reed's case as well. So in the course of that, they hired 2 people, and those experts reached opinions that there was no evidence that John O'Keefe had been hit by a car. Well, that's critically important because the only way that Karen Reed gets convicted is if the jury believes that she with her car hit John O'Keefe, whether it be regardless of what the count would be. That's the important point of the day. So the judge began by telling us why she suspended the case last time. There was a hearing going on. The prosecutor introduced some of the issues we're going to talk about tonight, and the judge said, I'm going to suspend this before the defense even responded. I'm going to suspend it now. And she said there were 3 reasons. Number 1 was that it raised questions of candor or truth-telling, and she didn't think it was fair to ask the defense counsel to just stand up and answer without having had a chance to reflect and consult with each other. She said it raises serious issues about counsel and also of Ms. Reed's right to a fair trial. The second reason, she said, was that what the Commonwealth was saying was inconsistent with her memory. Now, she never really explained that. That made it sound as if she was saying that the Commonwealth was saying things that were incorrect. Having listened to the rest of the day, I think she may have been saying what the Commonwealth was saying that the defense represented was inconsistent with what I did, but I was unclear on that. She said she wanted to take the time to be sure her memory was right. She'd gone back to review everything discussed at the last hearing, but she added a brand new point, all of her own, saying that there was a sidebar just 3 weeks ago, which the public had not heard. But both sides are supposed to provide information about their experts to each other. So the judge said at that sidebar, she was operating under the assumption that the defense could not provide the kind of discovery it's supposed to from the ARCCA witnesses because of a federal protective order. And she said, quote, counsel did nothing to disabuse me of that. In other words, saying that they had the opportunity there in the sidebar to tell her, hey, that's wrong, just so you know, this doesn't really apply. But they didn't do that. It was a bad omen for the defense. and she marked that transcript of the sidebar as evidence and read from it, where Jackson, one of the attorneys for Karen Reed, said, "Miss Reed has not violated anything. The Commonwealth has the exact same batch of information that we have about these witnesses. I didn't hire them. I didn't ask them to engage in additional protocols. He's got the same information I've got, and he got it at the same time." And she is saying at the time that you made that statement, you had not turned over emails that the ARCCA witnesses had sent to you. ARCCA is the name of their company. They had sent emails to you. They had even sent a proposed question and answer. So you, Alan Jackson, asked me these questions, and here's how I'll respond. They'd even sent that in, but that didn't get relayed to the Commonwealth until after this sidebar. So she said the third reason was that she needed some time just to reflect, that she didn't know what was going to flow from this. She wanted time to think about it. So there are two overarching issues that are running the show here. The first is what's going to happen with the attorneys for Karen Reed. The other, the other issue is what's going to happen to her experts. So, and there are two really important rules that I want to show you. The first is Rule 3.3a, rules of professional conduct. These are rules that apply to lawyers, that lawyers have to abide by. They were talked about a lot, and I thought you might want to see what they say. A lawyer shall not knowingly make a false statement of fact or law to a tribunal, or fail to correct a false statement, a material fact or law previously made to the tribunal by the lawyer. So in other words, when lawyers have a rule, a professional rule, that they aren't allowed to make false statements to the court. That's what that means to tribunal. It's anyone who's deciding it. If it's a jury trial, to the jury. If it's a court, then the court. They're not allowed to do that. And if they know that there's this false statement out there, and they know it needs to be corrected, they have to actually go out and correct that. They can't just let it stay like that. Now, the second rule that's really important is Rule 14, reciprocal discovery for the prosecution. This is one of the rules of criminal procedure in Massachusetts. Following the Commonwealth's delivery of all discovery required pursuant to, and they name some procedural rules, and on or before a date agreed to between the parties, or in the absence of such agreement, a date ordered by the court, the defendant shall disclose to the prosecution and permit the Commonwealth to discover, inspect, and copy any material and relevant evidence discoverable which the defendant intends to offer at trial. What this is saying in a nutshell is that the defendant has a duty to turn over information that's material to the case, that's relevant to the case, just like the Commonwealth does. The defense can't sit back and hold that back. Now, one of the arguments the defense is going to make is, yeah, the Commonwealth hasn't finished its duty yet, or hadn't at the time that we sent them this. So it's not like we were late. We weren't late on this. So we'll get into that more as we go through what happened today. So the federal investigation produced this ARCCA report, and it was, as the attorney explained, 3,000 pages provided by the federal government, including this report. The ARCCA experts were very important to Karen Reed's case because they had opinions that John O'Keefe's injuries could not have come from her car. So the defense put out several themes today. One was that ARCCA's reports, its opinions, were set in stone in February of 2024 when they provided a report to the federal government. From that point on, they'd written down what they had to say, so it wasn't as if they were changing it. So the defense argued there's no real harm to the Commonwealth of Massachusetts by the fact that they didn't know about these extra documents that were being sent between the defense and the ARCCA experts. And this came about in the last hearing. The prosecutor said, look, we just got two really important documents from the defense. These should have been provided before. In fact, Judge, they should have been provided back at the time of the trial. the first trial. And the fact that they weren't is a problem. And the Commonwealth kept saying, we don't want to throw out ARCCA. I'm not trying to throw out ARCCA. Said it frequently enough that the defense concluded, well, that's exactly what they want to do, is throw out these expert witnesses because they're so important to Karen Read's defense. But the documents were an email where there, and I'll show you this in an exhibit in just a minute. But there was an email from Attorney Jackson to one of the ARCCA witnesses. There were some emails back and forth. There was some discussion about whether or not they would be paid. That wasn't really resolved, the defense says. And then there was actually a payment. We'll get to that. That's one of the most important facts of the entire hearing. So the defense says, look, ARCCA had reached its opinions and those didn't change. Even if there were some documents that were missing, what does it matter? Because their opinions were already their opinions. It isn't as if there were changes to those. And the Commonwealth was allowed to contact them just like we were. They didn't belong to us. They didn't belong to the Commonwealth. They were experts for the federal government. The defense said also that the rules around this were set by the United States attorneys and not by this court. And they were really complicated. So attorneys could pretty easily mess this up. And that they pushed hard on the idea that the real reason behind this is to get rid of these important experts. So before we dive into the timeline in the video, I want to say a special shout out to the first 5 in the chat tonight: Bon, Angel LaFawn, Michael Lalonde, Susie Q, and Michael Manley. Special shout out to y'all. Glad to have you here tonight. So let's head into I want to start with a timeline that I hope will show you what exactly is being argued about. Let me make it as big as I can get it. I've already got it at 150%. Let's see. Yeah, it may run off. Let's see if I can get it all the way on the screen. Okay, that worked. We've got it at 200%. So hopefully we can all read it, including, most especially, me. So in March of 2024, March 20th, there was an email from Karen Read's attorney Jackson to ARCCA expert Wolf. And the title of the email was engagement. Engagement usually in the legal world meaning hiring an expert, retaining an expert. Very importantly, there was no CC to Yannetti, one of the other attorneys for Karen Read. The fact that the defense mentioned this each and every time is basically a signal that they are very worried about whether or not the judge is going to throw out Alan Jackson. And they're trying to at least salvage some of her legal team. And they would like to keep Yannetti, even if she's going to throw out Alan Jackson. They're obviously concerned about it. And they kept mentioning, there's no CC to Yannetti. There's no CC to Yannetti. So he couldn't have known about this, or might not have known about this. There's no evidence that he did. So in this email, Jackson told the ARCCA expert, send me your retainer agreement. I'll sign it and send it to you along with your retainer as required. And the person doing the argument today, Alessi, the person doing the argument for the defense, said at this point, there's no meeting of minds about payment. That instead, all we're doing is as required. And Alessi read that as if required, suggesting that maybe there wasn't any need to do that. Now let me add to the stage.
Wolf, thank you so much for taking the time to get on the phone with me this morning. Pursuant to our conversation, please feel free to forward an engagement letter to this email address. I will get that countersigned and returned to you forthwith, along with your retainer, as required. I have the good fortune of dealing with experts probably every week. And this is classic form parlance. If it's going to be required, you always hope for your client that they're not going to require a retainer. But the language is as required, as. Also, if you could attach a copy of your, Dr. Rentschler's, and Mr. Klein's CV, I would appreciate it. I look forward to speaking to you and your team soon as we iron out the logistics for your participation in the trial. At that particular point in time, there was no conclusion, no agreement, no knowledge that these folks would actually be testifying. There was certainly the hope, there was certainly the desire, but there was no agreement that they were going to be testifying.
So I think probably what happened in this case is that the attorneys got extremely busy as the case moved on toward trial, and a lot of things fell through the cracks. That's really typical when you get moved into trial. I didn't think this particular argument was really strong because all along it seemed incomprehensible to me that these experts would come in at their own expense without expecting to be repaid. That just seemed so unlike, I think I said that at the time. I don't get that. They charge a lot of money. They're very expensive. This is their business. And unless they thought it was some kind of PR deal, I couldn't understand why they would do this without somebody being expected to pay for them to do this. So let's add back the document that we were looking at. So the next thing that happened is 2 days later, Wolf emailed Jackson, again, no CC to Yannetti. And the lawyer for Karen Reed pointed this out. The U.S. Attorney's Office has asked that we pause on any further conversations until we receive additional information from their office. And the defense believes this is an extremely important email because of the words pause, the word pause, that there was a plan right then that everything was paused. So any discussions about whether they would get paid, even whether they would testify, everything was on pause while they waited for the United States Attorney's Office to make some decisions about going forward. So they say there wasn't an agreement at this point that where there was some kind of plan. Yes, they're going to testify, and yes, you're going to pay them. It was all kind of up in the air. Then in April of 2024, the Karen Reed trial begins, and Yannetti gave an opening. He never mentioned ARCCA, the defense pointed out today. Two most powerful witnesses of the trial, Alessi called them. And yet Yannetti, Karen Reed's attorney, didn't even mention them because he didn't know whether they were going to be able to testify. He still didn't know the answer from the federal government. So if there was an agreement, Alessi argued, well, they would for sure have mentioned that, because that would have been really something useful, something good they could have told the jury. Then on June 10th, 2024, the trial is ongoing. Karen Reed's trial is still going, and there's a hearing on the Commonwealth's motion to keep ARCCA out, to exclude ARCCA from testifying at the trial. And this was the court's remedy, since the defense said it literally could not comply with the rule of reciprocal discovery. So in other words, the defense is saying to them, look, we're not allowed to talk to the witnesses. There's this really bizarre situation where they were hired by the federal government, not by us. And normally we would bring them in and we would work with them and we would prepare reports and we would hand those over to the other side. But we can't do that here because of this weird rule where we're not allowed to talk to them. And the court said she found it really hard to believe that they were putting three witnesses up that they hadn't spoken to yet. I remember thinking similarly that seemed just really unusual. Yannetti said that's essentially it, but he added that the defense was only speaking to the witnesses for coordination of testimony and background, and that the defense hasn't been able to interview the witnesses regarding their findings. And the defense argued, yeah, that's actually true. So on the 18th, which is another 8 days, it's now time for that. And let me explain a little bit more. The court said, okay, I get that you can't produce this. You aren't able to talk to the witness. You're not able to get the witness to write out a report and explain what they're doing. So I understand that. What we're going to do instead, we're going to have voir dire. We're going to bring the witness in before the witness testifies, more than one witness. And we're going to let the Commonwealth ask questions and learn what they need to know. That'll be our substitute for the fact that you are unable to produce the discovery you normally would and should. So that happened. That voir dire examination happened on the 18th of June. And Wolf at that time was asked whether he had been paid. and said no. Let's add the
time you did your expert review, Dr. Wolf, and your consultation, you and I had never met. Answer, that's correct. 100% true. You did not know who I was. I did not. 100% correct. You had never met Ms. Little? No. That's correct. Mr. Yannetti? No. Fact. As a matter of fact, you had never heard of this case. That's correct. When did your analysis and conclusions, well, let me ask it this way, you finalized your report, you and your team, correct? Answer, correct. Question. And that report is contained in a multi-page document that was submitted following your analysis and your opinions and conclusions, right? Answer, correct. The defense didn't have anything to do with that. That's correct. True statement. You had never met us, didn't know who we were when we did this. Correct. 6, question. All right, it goes without saying, I'm going to ask it anyway. You haven't been paid by the defense. Answer, you have not paid us anything. No. 100% correct. And you don't work for us. That's correct. There was no engagement. There was no engagement letter signed. There was no retainer. Those discussions that were started on March 20th were paused with a March 22nd email, and they never were re-engaged. They were never re-engaged.
So, and let me clarify, this is actually trial testimony rather than the testimony at the hearing that you're hearing. And there was discussion, as you can hear, about there were statements that these were independent witnesses, that these witnesses were not directly connected to the defense. The judge is upset because she believes that there, in fact, was a relationship between the defense and between the defense attorneys and the defense and these experts, and that wasn't disclosed to her, wasn't disclosed to the Commonwealth, wasn't disclosed to the jury. That's what she's upset about. And she feels like that relationship was hidden. And in fact, there was even, we'll hear more about the payment issue.
They got to eventually get them on the stand, but there was no retainer. There was no terms of the engagement. To the best of my knowledge and my review of all these facts and discussions with counsel, there was no compensation as of June 8th. There was no promise. There was no reward. There was no inducement, unless one tries to define inducement as being the hope that you'll get to have these experts testify on behalf of the defense. There was no favoritism. The Commonwealth had the opportunity to interact with the ARCCA experts. They had the opportunity to call them as witnesses.
So as you can hear, he's arguing that this was at every turn, the actual answer was correct. In fact, the witness had not met Jackson, had not met Yannetti. So each time, whatever the answer was technically correct. The judge believes that there was an underlying hiding of this relationship, and there were some emails that suggested that they were working together. For example, the expert even drafted a Q&A. Let's go ahead and we'll put this back in the stage. So the 22nd, the voir dire of Wolf was on the 18th. There were more than, I've got Wolf in here, but there were 2 experts who testified at trial. Then on the 22nd, Wolf emailed the attorney for Karen Reed, Alan Jackson. Again, no CC to Yannetti, and the defense pointed that out. Wolf sent his qualifications, a general sense of what his response would be if he were asked questions, and said, make whatever changes you feel necessary. He said, I'm going to work on direct examination questions tonight. In other words, he was preparing questions for Jackson to ask him. So Jackson could just read the question, and he's saying, here's what my answer will be if you do that. That's exactly the kind of relationship or working together that an attorney might have with an expert witness. In fact, it's more than most expert witnesses would do. Most expert witnesses would expect you to write your own questions. But he said, make whatever changes you feel necessary. So the judge is looking at this and saying, this looks like a relationship where They're working together. This is not a relationship where there's some kind of question about whether or not they know each other. This is not an independent expert, and I was told it was. So was the jury. The jury was told this was an independent expert, and that's incorrect. So the defense argues, okay, Jackson actually brought out that point, the point where they said, if you don't want me to say this, I won't. Well, apparently Jackson did want him to say it, but that isn't really the point. And the prosecution argument is it doesn't really matter. It's not so much that the witness is saying, if you don't want me to say that, and they're hiding the point. The point is that they have such a relationship that the witness would say something like, if you don't want me to say this, I won't. That shows the relationship between them. That's what they're arguing. So then on the 23rd, the next day, it was Sunday, 2:59 p.m., Wolf emails Jackson again with an attachment. This is the Q&A written out for him. And that's not produced to the Commonwealth during the trial, before the testimony. It's not produced for another 6 months. February 13th, just a couple of weeks ago, is when they finally produced that. So on the 24th, Wolf takes a stand and says he hasn't been paid, and said that that's where you heard the quote from the transcript about how, no, he hasn't been paid. So the defense says, well, we'll skip that. That was just a technical point. So then on the 12th, the defense attorney, and this is, trial is over. Karen Reed there's been a hung jury. The judge has declared a mistrial, and the defense attorney gets a bill from ARCCA for $23,000. And then a couple of weeks go by. According to Alessi, the defense checks with the United States attorney on whether they are supposed to pay the bill. They were a little unclear, like, what kind of relationship do we have? Are we supposed to do that? Apparently they're told, yes, go ahead. And Alessi suggests the judge should call the United States attorney. And the judge, you could confirm this, judge, by calling the United States attorney, who will tell you that, yes, they told us we ought to pay the bill. And she responded, it was a little while later, she's like, I definitely will not be making an ex parte call. She was just apparently outraged at the suggestion that she would do that. She was definitely not going to be doing that. Let's have another little video clip right here.
The defense position is that there was absolutely no meeting of the minds that ARCCA was going to be compensated by the defense. It wouldn't have been a surprise if that would have been demanded of the defense, but those were paused. Those discussions were paused. And again, that's the recollection of the defense. So here's the punchline, Your Honor, with the invoice. It came out of the blue. It came out of the blue. It gets sent to Mr. Jackson's office in July. I can't reveal attorney-client communications, but I can tell you there's one person that was more shocked than most about the invoice coming in and the amount. So what happened? And this is, Your Honor, objective, these are recollections, information. The defense team called Mr. Adam Deitch at the U.S. Attorney's Office. What is this? Can we pay it? We supposed to pay it? I encourage Your Honor to communicate with the U.S. Attorney's Office about, did this conversation really occur? What was the substance of the conversation? Because, as I understand it, one of the questions of Mr. Deitch was, can we pay this? Are we going to be in violation of some expectation of yours? We want to do this the right thing. Mr. Deitch said, yes, you can pay it.
So the defense admits that, let me head over here, admits that ARCCA sent the documents before the witness testified, but that they were not disclosed for another 6 months until February 13th.
Talking about Saturday, June 27th, what was sent as an attachment with the email, and Sunday, June 23rd. So this was before the witnesses testified, right?
That's
and you
correct.
were saying that this was disclosed prior to the February 18th hearing, but was this disclosed prior to the witnesses' testimony?
The answer is no, Your Honor.
All right. I just wanted to be clear. That's how I.
And I'm going to get to that. To me, that's a Rule 14 issue, not a candor to the court issue.
What he's saying is, if you want to find fault with that, if you want to do something about it, Judge, then what you need to do is look at what are the remedies if people are late producing discovery. This isn't a matter of someone lying to the court or lying to the opposing counsel. This is an issue about whether or not they were producing what they needed to do when they were supposed to do it. And so you shouldn't pay attention to that. You shouldn't worry about that at this stage. So Alessi also, and we'll go ahead and run through the rest of our timeline points. So on the 12th, this is back in shortly after the trial, there's this bill. On the 24th, they check and they're told to pay it. The very next day, Karen Reed pays the ARCCA bill. That was an important point for the judge. Was it actually paid? And it was. On the 6th of February, at a sidebar, that's when the judge says Jackson told her the Commonwealth had everything the defense had when it came to the ARCCA experts, that these were experts who were not ones that they controlled. They were independent experts. They both had access to the same information. The judge is thinking, no, that's not true, because you had a Q&A that was provided to you by the witness that you never gave to the Commonwealth. You have information that you actually paid this witness that you've never told the Commonwealth. So that the judge is also concerned with the representation made at that sidebar. That's one of the things she was worried about. So then on the 13th, the defense produced documents to the Commonwealth. And on the 18th is when the judge abruptly stopped that hearing and said that she was hearing about what was going on. And today was the follow-up to that, where they were allowed to talk about that. So I have to move my screen around. Give me just a second to get everything together and see if I've shown you all of the video that I had in mind. Nope, there's one more I want to show you. So at this point, one of the arguments that the defense lawyer makes is that this is all acting to prejudice Karen Reed, that all of this hubbub about her lawyers and whether or not they lied and whether they hid information about their relationship with ARCCA, all of this is headed toward an appeal issue, creating an appeal issue for Karen Reed, because it's already really hard to get a jury. And now this jury will have heard a lot about Karen Reed, and they'll have heard a lot about her attorneys, and suggested that this is headed toward creating a fair and unfair trial.
What happens after these 10 misdirections? The court's comments go viral. And I'm not saying this for drama's sake. I'm saying this for what has impacted the defense 6 weeks before trial starts, while jury notices are out in the mail. Those words, based upon the misdirections that your court had to endure, have gone through, and I'll just name a few headlines in the Globe, the Herald, every TV outlet, social media exploded. And these are not trivial issues. And more than that, the veracity of counsel has been called into question. There's commentary of everybody about what's going to happen to certain members of the counsel's team, and whether it's intended or collateral damage. We've got the ARCCA experts, which are key parts of our case. Their credibility is being pillared throughout the public domain. And this could have been avoided had there been an accurate recitation of what had occurred. And Your Honor, I don't know if this can be remedied, but it surely shouldn't have been exacerbated.
So the argument from the defense is that the judge's comments, just the very fact that the judge has made a deal of this and has brought in and held this hearing, all of this is already operating against Karen Reed to prejudice her and make it more difficult for her to receive a fair trial. The judge did not seem to be swayed by that. She seemed to continue to be extremely upset about what's happened. There were a few more points I want to make sure you hear about. Ms. Little is the female younger attorney who works on the Karen Reed team. And at one point, there was a comment from Mr. Alessi that Alan Jackson doesn't do discovery. That's Ms. Little And so the judge asked her, well, what do you have to say about that? And Miss Little said pretty much what you would expect, which is she's the one in charge of discovery, but they tell her, okay, the judge says you're supposed to produce stuff, and so she'll take care of the brass tacks of doing it. And the judge also asked about whether when there were cases cited by the defense, then the defense was arguing you can't just throw out a lawyer. A defendant has the right to choose counsel. And that is especially true and most true in a criminal case. That's where the defendant has the right constitutionally to actually choose counsel. That's part of the Sixth Amendment. And so if you throw out her counsel, then you're violating her Sixth Amendment rights. And the judge said, well, as they were discussing cases, said, well, wasn't that maybe those counsel were not pro hoc, were they? Here's what she was talking about at the time. Alan Jackson, I don't know which other attorneys, Alessi for sure, I don't know about Miss Little, they are not local Massachusetts attorneys. They're actually from New York for Alessi and California for Jackson. And they have been admitted pro hoc vice, which means they're admitted just for the purpose of this one case. And they are under the umbrella supervision of a local attorney, and that's Yannetti. He's the one who brought them in to handle the case with him. And so they are going to be working with him on the case, but he has to be in the case, somebody does, from the state of Massachusetts, because that's a requirement in order to appear before the court. And typically, pro hoc vice counsel, since they are not truly admitted in that state, they haven't taken the bar there, they aren't subject to the same bar sort of standards. They are subject for the purpose of this case, but not generally. They don't generally have to abide by that because they don't practice there. But for purposes of this case, they are there. But it's also at the discretion of the court. So the court is allowed to introduce people and allowed to not introduce people. It's an extremely huge, enormous deal if a counsel gets knocked out when they're on pro hoc vice. Now, you might think, oh, what does it really matter? It's one case. They've got other cases. The problem is this. If one of the attorneys, let's say if Jackson were to get knocked out of this case and the court were to have a finding that he had behaved inappropriately and he was going to have his pro hoc vice revoked, every time you apply pro hoc in another state, you have to file a form explaining whether you have ever had a problem before, whether you've ever been denied pro hoc status before. And so when you do that, you're going to have to disclose that this happened. One time in a case I was handling, there was one of the lawyers on the team who had that happen, and it was a big deal. We had a real problem with that because every time we went to apply pro hoc in another case, they would raise this one problem he had, and we would have to try to get him admitted there. And if we couldn't, then that was huge because he was the primary attorney who was going to be handling the case. And over and over again, that remained a problem for many years until it sort of got so old it kind of fell off, I guess would be how I would describe it. So one of the arguments that the defense made was that a lot of what the Commonwealth had said was shady and wrong. And as far as they talked about this, saying, the Commonwealth told you this, and this was a misquote. I went back and looked at, I had AI transcribe parts of what had happened and parts of the transcript from last time. And I think that there may have been a truly problematic transcript from the court reporter in the last hearing, because the AI would have the prosecutor saying exactly the correct quote. And then what he was reading from the transcript, what Alessi was reading, was something different. So I do think there might have been a problem with that. He pointed out it wasn't really important. I didn't think it was worth spending time on tonight during our video. So maybe another time we'll take a look at that if it becomes important. When in his response, the prosecutor said, look, here's the point, Judge. ARCCA was not fully independent. We were all told that, including the jury. We were told that ARCCA was this body, was this special corporation hired by some unknown agency, never disclosed to the jury, but we know it was the federal government, and that wasn't true, that there was a bias, there was a relationship, and at a minimum, that should have been something the jury heard about. We all should have known about that, and I, or the attorney who was representing the Commonwealth in that case could have asked questions. So, and we can tell that there was this relationship because these witnesses were busy tracking their time. They billed for time before the trial. They billed for time when they were talking to Jackson. They billed for time when they were traveling. They billed for time at trial. And so those payments were tracked by them. How many hours were they spending and when? They wrote all that down. They were clearly expecting to be paid, and then we weren't told that. So the one last thing I wanted to talk about is the Alan Jackson made a comment to a reporter, and the prosecutor talked about that, said, look, Jackson told a reporter that he hadn't paid ARCCA. We know that's false now, Your Honor. We now have an admission from the defense team that they paid them more than $23,000. So obviously they did pay, and he's lying out in the world as well as here in this courtroom. So I thought you might be interested in seeing let's add it. Give it just a second.
He referred to, of all things, Mr. Jackson's response to a reporter. We're here talking about communications to the court. But to be clear, the reporter asked, did you pay for testimony? Did you pay for testimony? Mr. Jackson, of course, said, no, I paid for their time.
Did he say I paid for their time?
Pardon me?
Did he say I paid for their time?
Mr. Jackson?
I said the words, of course not. Did you pay these witnesses for their testimony? And I said, of course not. If the court were to ask me that question today, I would respond exactly the same way.
All right, so you just told that I paid for their time. That
No,
was not said, right?
That was not said, but I'm saying there's always some inference about what he said, that what was said, but that was his response, that was it. But so the premise of Attorney Brennan was, what Mr. Jackson said to the reporter was different from what you've heard in court today, and it wasn't.
So I thought you might want to hear exactly what was said by Yannetti in that interview, and then we can talk about it.
What was that about?
No idea. She didn't say.
Did you pay the ARCCA experts to testify in the first trial?
No, of course.
Hi, Alan. Subsequent to our...
So I think this goes to some degree in favor of the Commonwealth. Alan Jackson is kind of right, but he said to the reporter, did you pay the experts for their testimony? And he said, no. And there was a difference, I think, between did you pay the experts for their testimony or pay them to testify? I don't know. I think the judge will probably think that that is problematic. It was a little different from how it was explained, but I do really understand what Alan Jackson was thinking and was saying about that. I don't think there was anything. I doubt seriously that he intended anything, but it did come out as if no payment had been made. That's kind of the way it sounded like. So let me remove that and make this large again. So the last two nails in the coffin, I think, would have been that, and also that on February 15th, 2025, apparently there was a pleading filed, so just 10 days ago, and Jackson and Alessi and Yannetti signed it, but not Miss Little. And they stated in it that they request that the court deny the Commonwealth's motion to exclude, that the ARCCA experts were not hired or paid for by the defense, and that this attempt to keep the ARCCA witnesses out is a desperate and transparent attempt to exclude a neutral expert. And the Commonwealth said, look, this is exactly the same thing. They're still claiming this is an independent expert when we can see that that's just not the case. All right. So, Lynn, I want to thank you for the super sticker. Thank you very much. I'll take a couple of questions. And if you would put question marks at the beginning, I'll have a better shot at seeing them in the chat over here. So I believe, looking as an overview at kind of what's happening, the judge is very upset. I don't know if she'll cool down. We've seen that happen in the past in hearings, but I don't know whether that'll happen here or not. I initially thought that the judge would continue to be upset, but that it wasn't something where she was going to take action. Well, it sounded like a lot more than that. I thought it was possible she could take action. I thought that might be about to happen, but I was taken aback by just how planned this whole thing was, how planned the hearing was, her statements that were, she had clearly read everything, and if you ask me, had come in planning to ask the attorneys to take away their pro hoc vice admission to Massachusetts. They're admitted just for the purpose of Karen Reed's case, Alessi and Jackson, and I think she was at least going to revoke Jackson's. I don't know about Alessi. That would seem to be a little much. I'm not sure that would really be appropriate, but we'll see. I don't know. There also seemed to be some hint toward the end that maybe she was looking at Yannetti's. That would be a much bigger deal because he is a local attorney. And so obviously he would fight that a lot if that happened. All right. So looking at some of the questions, Kirby, if the docs were sent by the experts and not used, is it possible these were just overeager witnesses? And do you think the attorney should be given grace due to the odd circumstances with the feds? So I do think it's very likely that these got overlooked. I think probably they were getting emails from the defense experts, the defense was, and they're in the middle of trial. I can't even begin to tell you how intense it is when you're in the middle of trial. You're working 100% of the time. If you wake up at night, you're still thinking about the case. When you wake up in the morning, you're thinking about the case. There's no moment when you are not thinking, preparing for the case for the day. And so I think that it's very likely that it just slipped through the cracks. He was busy preparing for the witnesses and this was attached. Maybe he even looked at it and said, okay, yeah, those seem like pretty good questions. Maybe he even added them in. But I doubt seriously anybody was thinking, we should produce these to the other side. Should they have been? Yes. And I think the problem that bothers the court the most, the problem that bothers Judge Cannoni, is that there was this back and forth where they seem to have a relationship as if they're working together. If you don't want me to say this, I won't. And they seem to be talking, communicating. And then the attorneys came into the courtroom and suggested to the court, to the jury, to everyone that they were not actually had no relationship. These were just independent people and they were for the first time interrogating them. That wasn't really the case. That's what the judge is saying. That's why she's upset, and what she's arguing is, or what she is suggesting is happening here. That's the part that's gotten her upset. So do I think the attorney should be given grace was the second part of that question. And I would probably, in this particular case, if I were the judge, I probably would do that. But I am not sure that the judge is going to. I'm not sure she has to. That would just be sort of my circumstance here. I can understand her being upset. I just would think that's what I would do. So Jack asking, how do attorneys know an expert will support their case before they hire them? Oh my, what a question you have here, Jack. If the expert's finding ends up supporting the other side, are the attorneys required to disclose that in discovery? So what circumstance could there possibly be that every single expert happens to support the side that hires it? How does that happen? Well, the truth is, I'll have to do a rant on this one night. We're kind of late tonight, so I'll just make it brief. But I think that there is a lot of problem with the entire expert system as we have it. And people hire experts they know will support their case. Certain experts are known to always be on the defense side, always be on the plaintiff side, and they're hired, and in advance, that's the way it's going to be. That's the way it's going to happen. So I think that what's happening here is exactly what you would expect. And the reason the Commonwealth didn't contact ARCCA is they'd already staked out their position, which was pro the defense. So why would the Commonwealth contact them? The defense did because it was helpful to them. So it's an amazing coincidence that the expert always seems to support the side hiring them. Do you have to disclose it under most circumstances? No. If you contact someone who is a non-testifying expert, under most circumstances, you probably would not. There might be differences in certain states. If Alan Jackson is thrown out, can he still be part of the team behind the scenes? Ask Go Duke Basketball. That would be awkward. It's not that he couldn't do it and that it would be in, but it would not be, he would, if he's barred, let me finish a sentence here. If he's barred by the court, he's not allowed to be part of the case, then for him to come in and continue to work on the case would be really problematic and very dangerous, that for all the other attorneys who weren't taken out of the case. So I would think that would be really risky. I would think it would be okay for him to do transition and to, as he hands the case over, and to explain, what's happening with the case and what some of the important points are. But it would be an incredible loss to Karen Read if she lost Alan Jackson. He is phenomenal when it comes to cross-examination of witnesses, just unparalleled. I cannot imagine her losing that. It would be a huge problem. So Lynn, thank you. And Patricia, I want to thank you also for the super sticker. Thank you very much. And Tracy Walker has gifted 10 Lawyer League memberships. Thank you, Tracy. I appreciate that very much. All right, so going back over for a couple more questions, will Judge Beverly allow ARCCA to testify in trial number 2? Asks Elevate the Process. Definite question. That was clearly one of the things that they were talking about today, and there seemed to be some question. Particularly, I think the issue will be around the examination at trial of the witness. Now, the judge's concern was this relationship that seemed to exist between ARCCA and the defense. As she saw it, she saw a relationship there, and that they were working together, and there were emails back and forth. But then the witness said he had not been paid, and the witness said that he didn't know Alan Jackson, that they had not met before and things like that. And that I think the judge's concern, the Commonwealth's concern, is that implied something that was incorrect. The implication was this is an independent expert, and in fact, the expert witness must have been planning to charge all along because he was tracking his time. So if he was tracking his time before trial, during trial, on the way to trial, during trial, if he tracked it that whole time, there's only one reason, the Commonwealth argued, that he'd be tracking that time, and that's that he wanted to actually submit it. So I think there will definitely be a request from the Commonwealth to, well, there already is, to exclude ARCCA. And I don't know what the judge will do. I don't know, but it's going to be an issue. All right, looking for question marks at the beginning. Truth and transparency. Hi, Lana, how are you? Thoughts on your odds of AJ being tossed? My odds are 10% of her tossing anyone. This is my question. So what I said last time at the in my last video about this was that I thought in the end what would happen is the judge would just get the attorneys in trouble, give them a big lecture. How could you? I'm outraged, blah, blah, blah. Would talk about it, but not actually take action. That shifted for me today watching the hearing, because she really seemed to be upset. She seemed to be very organized and very prepared. She seemed to be moving in the direction of excluding somebody. I don't know how many people, but at least Alan Jackson. To me, that was my perception of where she was headed today. I was with you until this hearing, and then it seemed to me, well, maybe she actually will. I thought that would not be too likely, just because it will delay trial, and it's such a huge move. I think that was why I thought, I just couldn't imagine it happening. But after today, maybe I'm wrong. So Figgy, thanks for including all the videos. Jackson told the reporter, no. She believes, or Figgy believes, this is an untruth. So Jennifer, that wasn't really a question. No fair putting question marks, and then it's not a question. All right, Jennifer, if the invoice came after the trial ended, why would they provide that info for the trial that ended in a hung jury? It's not so much that they should have provided it earlier. One of the arguments the defense made was, look, it wasn't even time for us to, there hadn't been the certification from the Commonwealth that they'd finished their discovery, and we don't even have to turn anything over till after that. That wasn't, I don't think, the point that was bothering the judge and the Commonwealth. The point that was bothering them was they told the jury there was no payment. There had been no payment, when it appears maybe there was contemplation that they were going to pay, and they were expecting that to happen. So they were going to be paid, but telling the jury no. So that's, I think, what the issue was. All right. Denise, do you know the next court date? Yes, that is a good question, Denise. I had that in here. I think it's next week. It's next week. I'm trying to remember what day it was. Maybe if I go over here, it was toward the end. Tuesday at 9 and Wednesday and Friday. But I think she'll have this decided by probably Tuesday. She may take it under consideration when everything's finished, but I think that's what it will be. All right. Kate, why doesn't it count that the feds asked them for this report? Of course, each side was sent the report and the defense chose them. So the defense pays for travel, accommodation, and being on the stand. I do think it counts. I think what you're asking me is, doesn't it make them more independent that the feds hired them? They weren't initially hired by the defense. Yes, I think the defense was totally free to say, we didn't find you. Somebody else hired you. You'd already issued this report, and now we just have put you on the stand. I think the judge, Commonwealth, are arguing they took the argument too far. That's the argument that they're making. This is Figgy's first live. Congratulations. We are glad to have you. And what AG, state or federal? So I don't understand the question, WB. I'm sorry. The federal government, the United States attorney would have been involved, and the state is prosecuting Karen Reed. The federal government was conducting an investigation. And from what the rumor is, they've decided to indict absolutely no one after that federal investigation as far as the Karen Reed case is concerned. That's the rumor out there. We haven't heard, I haven't seen that confirmed yet. Okay. Lorena asking me about the Supreme Court's decision about Karen Reed. I assume you mean that there will be a trial, that they will not accept the verdict. It wasn't even a verdict. There was rumor that some of the jurors had actually made a decision, not just some, all of the jurors had made a decision on 2 of the 3 counts, and that the hung jury wasn't really appropriate. The judge should have found in Karen's favor on to those 2 counts. Only the remaining manslaughter should have been on the table for this next trial. And the court said that that was not going to be what the court was going to do. The Supreme Court said, no, I agree with the trial court. There needs to be a completely new trial in this case. We did a whole video on that, and you can find it in the playlist for this particular, for Karen Reed, and you can find something about that. All right, look, Chuck Ward, thoughts on the case law quoted by the defense. I don't have any specific thoughts on that. I thought that the back and forth with the judge that I mentioned earlier was pretty much where the judge is headed on that. All right. Okay. Well, we will be live tomorrow night at 7 p.m. Eastern. We are almost surely going to be covering the hearing tomorrow in Donna Adelson's case. She says that she has been attacked in the prison. She wants out. The jail, she's not technically in prison yet, but that she wants out. She has a lot to say about that. She says she needs medical care, like having her ears cleaned, and she's not able to get that in the jail, so she wants out. So we will find out tomorrow what happens with that. I want to say hi to Magic Lady, who has been a member for 12 months. That's almost as long as we have it. So I'm so glad, Magic Lady. Glad to have you along. I will see y'all tomorrow night at 7 p.m. Eastern.